Good evening. I'm Ginny Sloan, and I'm president of the Constitution Project. As many of you know, TCP is a bipartisan legal watchdog that brings together experts from across the ideological spectrum to develop consensus-based solutions to some of the toughest constitutional challenges of our times. I'm delighted that all of you could join us this evening for a candid conversation about the state of the American criminal justice system, and given who our panelists are, I'm sure it will be quite candid. I'm especially delighted that my law school classmate and longtime friend, Judge Alex Kozinski, will be a part of that conversation. Earlier this year, Judge Kozinski published an article entitled Criminal Law 2.0 in the Georgetown Annual Review of Criminal Procedure. In it, he raises some of the same concerns that TCP and others have been addressing for nearly 2 decades: the uses and misuses of forensic evidence, prosecutors who hide exculpatory evidence from defense counsel because they're more concerned about winning than about justice, ensuring that criminal defendants have effective assistance of counsel throughout the process, even if they lack sufficient resources to hire a lawyer on their own, making sure that those convicted that the sentence is appropriate to the crime, to name but a few issues that he raised. Judge Kozinski observes in his article that, quote, much of the so-called wisdom that has been handed down to us about the workings of the legal system and the criminal process in particular has been undermined by experience, legal scholarship, and common sense. This troubling indictment will serve as the backdrop for what I know will be a spirited and substantive dialogue this evening. Before I introduce our panelists, let me thank our co-hosts for the evening, Democratic Senator Patrick Leahy from Vermont and Republican Senator Mike Lee from Utah. Their offices have been incredibly helpful to us in organizing this event. Yesterday, Senator Leahy cast his 15,000th vote as a U.S. Senator, more than only 6 other members of the Senate in the entire history of the Republic. The vote on which Senator Leahy reached this historic milestone was on an amendment to strengthen the privacy provisions of the Cybersecurity Information Sharing Act. Not surprisingly, he voted in favor of more privacy, and we applaud him for that. Senator Leahy has been a staunch defender of civil liberties and privacy rights throughout his career, and for that, TCP was proud to name him a constitutional champion earlier this year. And now I'd like to introduce the panel. Mike Lee, who will join us at shortly after 6, is a Republican senator from Utah, first elected in 2010. He spent several years as a lawyer with the law firm of Sidley and Austin, specializing in appellate and Supreme Court litigation, and then as an assistant U.S. attorney in Salt Lake City, arguing cases before the Court of Appeals for the 10th Circuit. He served the state of Utah as Governor John Huntsman's general counsel, and he also clerked for Justice Samuel Alito, both at the Third Circuit Court of Appeals and at the Supreme Court. And I want to add that Senator Lee also voted for the privacy amendment to the Cybersecurity Information Sharing Act. Judge Alex Kozinski was appointed by Ronald Reagan to the United States Court of Appeals for the Ninth Circuit in November 1985 and served as Chief Judge from November 2007 until November 2014. Prior to that, Judge Kozinski served as Chief Judge of the U.S. Claims Court, as Special Counsel to the Merit Systems Protection Board, and in the Office of Counsel to President Reagan. He also clerked for Chief Justice Warren Burger and for then Circuit Judge Anthony Kennedy. And most importantly, he is an avid Bruin. Noted criminal defense lawyer Stephen Bright teaches at Yale Law School and many other places, and he's the president and senior counsel of the Southern Center for Human Rights. He's tried capital and other cases and argued cases before state and federal appellate courts. He's argued before the Supreme Court and has another argument before that court just next Monday, a particularly egregious case of discrimination in jury selection. Fuller biographies for each of our panelists are available in the program. Our moderator for this evening is Dahlia Lithwick, a senior editor and legal correspondent for Slate, where she writes the column Supreme Court Dispatches. Her work has also appeared in the New Republic, Commentary, the New York Times, the Washington Post, and Elle, and on CNN.com. I'm an avid reader of Dahlia's work because she's one of the funniest and most insightful commentators there is. And with that, let me turn the conversation over to Dahlia.
I want to thank Ginny and the Constitution Project and Senators Leahy and Lee for making this possible. I've been doing this long enough that I don't often get just giddy with delight at being on a panel, but I am giddy at being seated next to the two gentlemen and thinkers and scholars on either side of me. Let's stipulate, just for purposes of this discussion, that you've all done the reading, which is Judge Kozinski's really, truly path-breaking law review article. And then if you haven't done the reading, you can ask questions at the Q&A about what we were talking about. But I really want to start with what's going to sound like a fatuous question, but I think that Judge Kozinski's indictment of the system is so widespread and so deep that I'm going to ask the question, what's left? In other words, if we really are to say that most forensic evidence, most experts are not good, that junk science is junk, that eyewitnesses are unreliable, that juries get it wrong, judges make mistakes, prosecutors have wonky incentives, is there something that works about the currently configured criminal justice system? Because it just appears so damning at every level. Is there something that you're bullish on that we could start with? And maybe it sounds fatuous, but I mean it.
Well, am I on? Am I on now? Well, as I thought I was careful to say at the beginning, what I was trying to do is raise problems and issues with the system. I think there's many aspects of the system that we've taken for granted. We grew up in this culture. We grew up, many of us grew up with Perry Mason and Nancy Drew, there we go, and we sort of, and 12 Angry Men, and we know so juries are very careful and they parse the evidence carefully, and I saw 12 Angry Men and I said, boy, if that's how juries work, I want to be a lawyer, because so I think we grow up in this country with a faith in our criminal justice system. We are told and we believe that it's the best system in the world, that it almost never gets it wrong. If it does get it wrong, it usually is by letting a guilty person go free rather than the other way around. The reality is different in many ways. Lots of people who are in fact not guilty do get convicted. We know that based on exonerations. We know it based on studies, and so we know that we do make mistakes, far more mistakes than I think most of us are aware of, and that the components of the system, various components of the system, which we sort of take for granted are sort of safe harbors, turn out not to be so safe. Now, whether all of the things I raised as problems turn out to be problems or issues, I don't know, but I think we need to at least take another look, and it needs to reconsider. For example, forensic evidence. Nancy Gertner, when she was a district judge, wish she was still a district judge. She was a great judge. She's now a great professor at Harvard. Used to hold Daubert hearings in cases involving forensic evidence in criminal cases. For years and years and years and decades, and perhaps going back centuries, we have sort of taken, accepted that people who are experts in criminal cases are not really sort of experts the way we would treat them in civil cases, that they need to be subjected to testing. If a fingerprint expert says that two fingerprints are the same, he must know what he's talking about. Well, it turns out when you do actual blind tests with sort of known samples, people who are supposed to be experts get it wrong a lot of the time. And that sort of makes you look at the matter in a different way than if you just assume, boy, if the expert says these two things are the same, it must be the same person. And I think you can have the similar skepticism and should have similar skepticism about a lot of things. Nancy Gertner did, I think, has an opinion on handwriting evidence. Now, I don't know, until I read her opinion, I thought if an expert said these two samples was written by the same person, it must be true. Well, it turns out it's not always true. It's just like any other kind of forensic evidence. So I just think we need to bring more skepticism to various aspects of the system. I still think the system works well. I think the system gets it right most of the time. But I do think that it makes mistakes more often than we have appreciated, and I think that's worth a careful look.
So I guess I'm going to turn on my microphone. I think I want to ask you a version of the same question, which is, until I read Judge Kozinski and Brandon Garrett, I didn't think people confessed falsely. Seems like confessions are a thing we should be able to rely on, except they're not. Eyewitnesses are not reliable. Go through the list. What evidence is really evidence? If, in fact, everything we believe that are the foundations of a trial are really as suspect as Judge Kozinski leads us to believe they are.
Well, I want to say how honored I am to be here with my good friend Alex Kozinski. He and I have debated over the years, and I really don't have much to debate with him tonight after reading this article. I'm just here to say amen with regard to a lot of comments that he's made.
I knew you'd come around, Steve.
Yeah. Well, we won't get into a debate about who made the longest journey, but I refer you to our debate in the Georgetown Criminal Law Journal, and you can sort of look at that and look at this and see where we are. But I think what he's right about is Justice Marshall used to talk about constitutionalizing wishful thinking. What we would like for it to be, we grow up pledging allegiance to the flag and saying with liberty and justice for all, and gosh, that sounds great, and we'd all like to believe it. It's not true. It's never been true in the history of the country. There's never been justice for all. If you're poor, if you're a member of racial minority, otherwise disadvantaged, there's probably no justice in the system for you. With regard to the forensics, I think what's happened with forensic evidence and what happened, and Judge Kozinski touches on this in his article, or talks a lot about the prosecutorial function. We've given so much power to prosecutors. We've moved so much power away from judges and to prosecutors. And then we've turned things like crime laboratories into arms of the prosecution. So instead of having people like from the National Academy of Sciences or some objective assessment, what you really have are people who are advocates. A lot of the experts that I see testifying are people who were beat cops who were sent up to Quantico, the FBI training program, for 2 weeks, and then suddenly they came back and they were an expert in fingerprints, tool mark identification, just about any area, blood splatter, you name it, and every opinion they gave was always consistent with the prosecution's theory of the case. We've just corrupted this area. I've seen people testify as medical examiners who are not forensic pathologists, have a PhD in chemistry, and are giving all kinds of testimony that any competent honest forensic pathologist would say you can't possibly draw those conclusions from examining a body or blood splatters or whatever it may be. I don't know if we can ever accomplish this, but there's a real need. When I was here as a public defender back in the 1970s, I believe then, and I think it was true, that our medical examiner's office was straight down the middle. And they were all, forensic pathologists, and that when a body was taken there after a homicide or whatever kind of death it was, that they called it exactly as they saw it. Now, they might not be right every time. Everybody makes mistakes. But those of us who were public defenders could go down and sit down with Leroy Riddick and say, tell me about your autopsy, tell me how you got to this conclusion, tell me whether this might work, whether that might have been a possibility. and then when they testified, you didn't have the feeling that they were stretching it for the prosecution. Since I've gone down south, I've never seen an expert like that. The pathologists are all, in fact, this case that got reversed in March out of Alabama, Anthony Ray Hinton, some expert in Alabama testified that the bullets fired from the gun or that were recovered in the bodies came from a gun recovered from, I think, his sister's. The defense had a witness to do a ballistics test, which of course involves putting the bullets on a compound microscope and looking through it. This fellow was blind in one eye. So it's very hard to do that kind of ballistics test. And the Supreme Court reversed summarily ineffective assistance of counsel. Alabama could not find a person who would say those bullets matched when the case came back for retrial. And so they dismissed the case and let Mr. Hinton go. And at least that's a slight improvement, because before they had somebody over there at the crime lab who would say just about anything, including that these bullets matched, when the top people at the FBI and everywhere else said clearly they didn't.
Judge Kozinski, I imagine it's going to be like asking you to pick a favorite child, but you list your reforms, and I'm wondering if you have one or perhaps two of your proposed reforms that you think would make marginally the greatest difference, and maybe if there's a reform that you think is a fairly easy fix, and maybe those are two different questions. But do you have among your laundry list of proposed reforms something that you think would really profoundly change the way we do justice?
Well, I think any of them would be a significant change. One of the concerns I have is the number of people we have in prison in the United States. We have 5% of the world's population. We have 25% of the world's prison population. One of the very four prisoners is in America. Next in line is China, with 1.6 billion people, and they have 16% of the world's prison population. So it's we are way off the charts. When you consider equivalent countries to ours, countries that sort of look like us, like Canada, England, France, Germany, Australia, New Zealand, the population, our incarceration rate is 700 per 100,000. In countries like Canada, England, so on, it goes somewhere from the low, just around 100 to 125, 200 the most, and this is just a significant disparity. And the reason is that we have, for equivalent crimes, we just simply impose much stricter punishment. You may say, well, maybe we have a different crime problem than everybody else, but it turns out we don't. Our crime rates have been dropping. Crime rates in other countries have been dropping, and we have about equivalent crime rates to other countries that, again, are like us. So it's not that either we have a bigger problem that we solve by incarceration, or that the fact that we have so many people in prison keeps us from having a greater crime rate. At least it's not what it looks like. So in thinking about reforms, one of the things that occurred to me is we never tell juries, or we almost never tell juries. We do in capital cases, but in non-capital cases, we generally do not tell juries what's at stake, how much the defendant is going to get if convicted. I've served on a couple of juries myself. I had no idea. I had to guess as to why this case went to trial. I have a pretty good guess, and as a matter of fact, months later or years later, I ran into the public defender and my guess was confirmed that they were facing 3 strikes, so that's why they went to trial in the one case. But we never tell jurors what is really at stake. And it seems a little backwards to me because we don't make life decisions without knowing the stakes. I mean, part of the decision-making process in deciding how careful we're going to be and how sure we want to be is being told what is the outcome. I think jurors should be told, and I think jurors should be asked, maybe not conclusively to set the sentence, but also their view, and their view should be taken into account. We don't do that, and I think that if prosecutors had to face the idea that jurors would be told what the stakes are, they might make more conservative charging decisions. And perhaps juries, judges, if the sentence ultimately imposed by the judge, if they hear the voice of the juries, they might well wind up imposing lower sentences.
Steve Bright, I think I want to ask you the same question. Was there one of the myriad reforms that Judge Kozinski put forward that you thought either, aha, that would make everything better tomorrow, or, aha, this would be really easy to implement? Maybe easy is not the right word, but that this is a small thing that could make a huge difference?
Right. I don't think there's a fairly easy fix because I think there's just so much pushback by the people that have the power. The one thing about the criminal justice system is that almost all the people in it are poor. In the federal courts, there may be a few more people of means who are in the federal courts, but in the state courts where I am, and that's where, you know, of the 2.2 million people that are in prison, all but 200,000 are in the state jails and prisons. So that's where we're locking people up. I think finding an easy fix, first of all, there are too many states. Secondly, the poor person accused of a crime, as Attorney General Kennedy said, has no lobby, so there's no power. I mean, Judge Kozinski recommends repealing the restrictions on habeas corpus, for example, which I think would make a tremendous difference, because one thing we're just not willing to look at is that when you have a system of elected judges in the state courts, the judges just simply cannot enforce the Constitution. I mean, politically, it's just not possible if they're going to keep their jobs. That's why judges in Alabama override the juries, and the jury gives life. I mean, I tried cases in Alabama. You get a life sentence from an Alabama jury, you've done something, I'll tell you. But then the judge, just as nonchalantly as issuing a fine in a traffic case, overrides that and imposes the death penalty. About 25% of people on Alabama's death row are overrides. But the same thing happens when the prosecutor strikes all the African Americans during jury selection. The judge politically is not able to say that's a pretextual reason, your real reason was race, and therefore I'm not going to allow that. He'd probably be challenged by the prosecutor in the next election if he or she did. And besides that, just psychologically, that's extraordinarily hard to do. I think one of the things the Supreme Court has done that is unfortunate is in a number of areas they've sort of adopted procedures and said, if you follow these procedures, we'll assume they work. We won't actually look to see if they worked. We'll just assume they work. You know, with regard to whether race comes into play, they say in Turner versus Murray, you can ask a conclusory question, well, the defendant is black and the victim is white. Do any of you have any racial prejudice that would keep you from being fair? You don't see a lot of people raise their hands, although the case I'm arguing on Monday, one of the jurors did say, based on the race of the defendant, race of the victim, I could not be fair in this case. I couldn't fairly decide it. But there are a whole lot more people that aren't ponying up and saying that. So we ought to be looking behind the procedures to see if they really work or not. Same thing with sentencing, that we don't look at capital sentencing, for example. In McCluskey versus Kemp, the Supreme Court said, you know, if a state minimizes the risk of race coming into play by having these procedures, we're not going to look behind the procedures to see if they worked or not. We're just going to assume they work. Oh, it's preposterous. They don't work. Race does come into play. Almost nobody denies that who looks at the reality of this. And so we have to start looking at reality. But there's a tremendous desire, I think, to try to just whistle past the graveyard and pretend that some of these things are not the case.
Judge Kozinski, do you want to talk about the race valence and also the politics valence that Steve Wright just referred to?
Well, I did mention one of the reforms I thought doing away with elected judges would be an important first step. Supreme Court considered the issue, and I think Justice O'Connor has, ever since she stepped down, has been lamenting the fact that she voted what she now thinks is the wrong way on this issue. It's too late. A lot of justices step down and then say, whoops.
Right.
You sometimes wish they'd say whoops before they step down, but I guess wisdom is better coming late than never. The race issue is much more difficult because much crime is intraracial. Blacks tend to have victims who are black. Hispanics tend to have victims who are Hispanic, and people live in neighborhoods, and that's where crime happens. So I am probably not. I think that's a much more difficult issue than the question of elections. I know there are judges out there who think they can be fair, and they say they can be fair, despite the fact that they're facing an election. But as Arthur Kaus said, great justice of the California Supreme Court, it's like ignoring an upcoming election is like ignoring the crocodile in the bathtub. So I think that is something the Supreme Court could do, and with one stroke eliminate that problem.
I wonder. Oh, go ahead.
Can I just say something in regard to that? And since Justice O'Connor left the Supreme Court, she's pretty much dedicated her life to trying to convince states that they should replace their election systems with other systems. And as best I can tell, she's gotten nowhere with that. I mean, I don't know how many seminars I've been to and how many programs she's had and gone places and engaged the bar and the judiciary and all these people. I mean, I wrote an article about this a long time ago, 1980s, or maybe early 90s, talking about judges and the politics, death in the judicial politics. And I thought at least we might get past partisan elections. Like in Alabama and Texas, the judges run on a party, Republican or Democratic ballot. And then maybe they at least go to nonpartisan elections, which really doesn't make much difference, but at least a little window dressing makes it look a little fairer than it is. They don't even do that. We still have partisan elections. So I had a friend who's on the Texas Court of Criminal Appeals. He said Ann Richards got elected, and I was swept onto the bench. And George W. Bush got elected, and I was swept off the bench. And he said, it didn't have anything to do with me and how good a judge I was or anything else. It had to do with who was at the top of the ticket. But we do know that in case after case after case, judges have been targeted for their votes in death penalty cases and have been voted off the courts. I mean, just last year in Ohio, which, you know, you would think not as much of a backwater as some places, two justices, Justices Kennedy and Justice French, were on the ballot. Both of them were running ads that made it look like they were running for sheriff. I mean, they really are talking about how many times they imposed the death penalty, how many life without paroles they had, how many people they had locked up. I mean, it's like this was all they were running about. 6 days before the election, Judy French authors an opinion upholding a death penalty case of a black man who was convicted and sentenced to death for killing a white police officer. 6 days before the election. It was the kind of final part of her election strategy. This is why she's running these TV ads talking about how tough she is on crime. I think it's unconscionable that she would do it, and I think it's unconscionable that the other members of the Ohio Supreme Court would go along with it. with releasing the opinion right before the election instead of waiting until after. But that's what you're dealing with elected judges in these cases.
And probably folks saw the study that just came out that showed, surprise, surprise, elected judges will, happily sentence much, much harsher sentences for exactly that reason. The incentive is never going to be the soft on crime judge. No. And isn't that the same political pressure that's infecting the prosecutor's office too? Nobody ever gets to be a renowned prosecutor for being a sensitive guy.
Well, and I wanted to follow up on what Judge Kozinski said about that too. I agree with him. The crimes are all generally within the same race: black on black, white on white, Hispanic on Hispanic, so forth. The thing that's disturbing, well, there are many disturbing things about policing and other things, but when we get to how people are treated in the criminal justice system, the people making all the decisions are white. 95% of all the prosecutors in this country are white. So the decision, like in St. Louis County, is made by one white man who decides, to abuse the grand jury process by having this star chamber proceeding and exonerating this police officer instead of having what I thought this country stood for, which was a public trial with a jury where the evidence is put on and people are cross-examined, not some secret proceeding where there's a very selective presentation of evidence. But generally, in the part of the country I practice in, the criminal courts are the part of society least affected by the civil rights movement. All the decision makers are white. The judges are white, the prosecutors are white, and even in communities with very substantial African-American populations, all the jurors are white because the prosecutors are striking all the jurors of color. And that's a hard one to change, but in terms of, this is years. I mean, in Georgia, there's no secret that the judicial districts were all drawn to dilute the black vote. So if we want to deal with this remnant of Jim Crow, we have to redraw the judicial districts and try to have a judiciary that more reflects the population of Georgia or Alabama or whatever state it may be. There's not much movement in that direction. And I think that while a lot of my best friends are prosecutors, and many of them are conscientious and absolutely honest, hardworking public servants, I think there are many people that, because of their limited life experiences, just simply, we know in Georgia you're much more likely to get probation on your first offense if you're white than if you're black. And I think the judge sitting up there, I didn't think he's racist. He sees that white kid up there, and that could be his son. And this is a kid, he's all dressed up, and his parents are there, and he can make it in a program. And then he sees that young African-American, exactly the same circumstances, but maybe he's wearing an earring and a T-shirt or whatever, and he sees a thug. And so the white kid gets probation and probably goes on to live a useful and productive life. And the black kid gets prison, or the juvenile prison, and probably is going to have a very hard time ever getting the ship erected again because of how horrible our prisons are. So I think race just permeates every decision: the bail decision, the charging decision, the plea bargaining decision, the sentencing decision. And part of it is racism, and part of it is just complete insensitivity, or just strangers in a different world.
Judge Kozinski, do you want to talk a little bit about some of the reforms that you propose for the prosecutors' offices?
Well, the prosecutors, as Steve has mentioned, prosecutors hold a lot of power. They make a lot of charging decisions that can put a great deal of pressure. Why do people plead guilty when they believe they're not guilty? A lot of times it's because the option of going to trial and the risk of having a life-crushing sentence or a real-life sentence are just unbearable. And so various prosecution decisions are made, decisions as to evidence and when exculpatory evidence is presented to the defense, whether it's presented at all. All of those things have a tremendous effect on the fairness of the process. Now, that having said, in my experience, most prosecutors, overwhelming number, are ethical. They do a great job. They are scrupulous. Of course, I see the prosecutors in the federal system, and that's been my experience. But there are lots and lots of documented instances of unscrupulous practices by prosecutors and by police that result in innocent people going to prison, or people who might be innocent who choose not to go to trial because either they are not given the exculpatory evidence in time, or because they face such huge risks in going to prison that if they go to trial, that they just can't take the risk. So I suggest a number of reforms, or a number of suggestions that enforcement of Brady, by having judges enter Brady orders, Brady compliance orders, is one idea. And not only should Brady evidence be presented, which of course is constitutional duty, but it should be done early enough in the process so that defendants can take into account in making their investigations, and also in making decisions, informed decisions as to whether or not to plead guilty. Now, there's some dispute as to how much of a Brady problem we have. And one of the things about Brady and the need to disclose evidence is a lot of times we don't know whether it has been complied with. Most Brady violations go unnoticed because the evidence is never disclosed. Or sometimes it's found years and years later, and then the courts say, oh, well, it was, courts are very reluctant to set aside a conviction and sentence, particularly one that happened decades ago or many years ago. So there's oftentimes a tendency to say, well, this was harmless error, this was not material. And we, as judges, spend a lot of time guessing as to what happened in the jury room. So you're making hypotheses about what happened in the jury room. So another one suggestion I've made, both here and in another publication, is we ought to put cameras in jury rooms. We ought to see what the juries do, not necessarily on real time, not necessarily look at all of them, but if there ever comes a time when it really makes a difference to find out what did the jury actually do, let's take a look at it. We're no longer in the Middle Ages where right now we can record these things, we can maintain them, and maybe we no longer need to do the speculation and say, well, this wouldn't have made a difference. It's very hard to tell whether a particular piece of evidence would or would not have made a difference. And most of the time, when faced with sort of a close question on that point, and with the prospect of freeing somebody who has been put away by a jury and has served many years in prison, judges tend to err on the side of saying it was harmless. Maybe we shouldn't be making those decisions.
Could I ask this? Why not? I mean, Brady is one of these things that can't possibly work because the prosecutor doesn't know what's exculpatory because he doesn't know the defense theory of the case. And we have all this time, as Judge Kozinski points out, after the fact, trying, well, what difference did it make if we ever find out? Why not just simply have open file discovery, which would then obviate this whole problem?
It's been tried in North Carolina. It seems to work.
Well, they have it in Florida and Missouri and have depositions, too.
Hello, Senator.
Hello.
So, I'm delighted to welcome Senator Lee. You've just walked into a fascinating discussion on reforming prosecutorial misconduct and Brady violations, but I don't know if you had remarks that you wanted to make just on general criminal justice reform, or if you want to... Okay.
Sure. First of all, if you're speaking about prosecutorial violations and Brady problems, in my small town of Alpine, Utah, we speak of little else other than those things. So it's a great opportunity to talk about those. But if it's all right, I'd like to talk for a little bit about the sentencing reform project that I've been involved in for the last few years. About 12 or 13 years ago, when I was an assistant U.S. attorney in Utah, I witnessed a case being handled by our office. One of my colleagues at the U.S. Attorney's Office came to me and told me about a case that he had. It involved a young man named Weldon Angelos. He was a young man in his mid-20s. He was the father of 2 young children. We were prosecuting him because he had sold marijuana on 3 separate occasions over a 72-hour period. Pretty small quantities, dime bag quantity, more or less. He had a gun on his person at the time. And as a result of all that, the way he was charged resulted in a 924C enhancement, and each of his charges was treated as a predicate offense, such that he ended up receiving a minimum mandatory sentence of 55 years. Ooh. Now, there was not one person involved in that prosecutor, in that process, not the prosecutor, not the judge, certainly not the defendant or his attorney, who believed that that sentence was just, who believed that that sentence was in any way commensurate with or proportional to the severity of the offense. The judge, in fact, former federal district judge, now former, then current, federal district judge Paul Cassell, hardly somebody who was regarded as soft on crime, even wrote an opinion prior to sentencing Mr. Angelos saying, this is wrong, this is unjust. There is no universe in which this makes sense to send a guy like this away until he's about 80 years old, just for selling marijuana on 3 occasions over a 72-hour period. But he explained his hands were tied. There was nothing he could do about it. There was no way he could exercise his discretion in order to impose a lighter sentence. And so he explained at the time, Congress has to fix this. Well, I, of course, remembered that experience because it was a pretty significant memory of mine. And when that story was added to a catalog of other stories that I heard from various judges and attorneys around the country, after I got here to the Senate, I realized that we need to do something about the issue of overcriminalization and about the use of minimum mandatory penalties. You know, our federal prison population has increased roughly 9-fold over the last 35 years. This doesn't reflect and is not the product of a 9-fold increase in the crime rate. We have not seen 900% increases in crime over that time period. Rather, it reflects a few trends. One is the over-criminalization of the law generally. Another is the over-federalization of criminal law. And yet another trend is the increased reliance on frequently excessive minimum mandatory penalties within the federal system. So we had a pretty massive reform of the federal criminal justice system back in the mid-1980s. This was part of the let's be tough on crime wave. And I understand that there were problems with the old system that we had prior to that time. But I think Congress may have gotten a little bit carried away, or at least might have been not entirely cognizant of what it was doing to our criminal justice system when it was ratcheting up minimum mandatory penalties. Politicians like to be known for certain things. No politician really likes to be known for being soft on crime, for saying, well, that's okay, well, let's just let criminals go. And so in order to resist and in order to avoid the charge of being soft on crime, politicians seem to almost try to out-macho each other. Let's prove who is toughest on crime. And it was almost like a dare. Every time somebody would up the ante would be met and raised again. That's how we end up with a 55-year sentence for a guy who sold 3 dime bags over a 72-hour period. So I ended up joining with my friend Dick Durbin. Now, Dick Durbin is a liberal Democratic senator from Illinois, and I'm not. But I found over the last few years there are a number of issues on which Dick Durbin and I agree. And the need for criminal justice reform is one of them. The fact that we come from opposite ends of the political spectrum doesn't make a difference in this area, because this is an issue that's neither Republican nor Democratic. It's neither liberal nor conservative. This is simply an American issue. And this is an issue on which I think liberal Democrats and conservative Republicans and everyone in between can agree that when we think about the intrusiveness, the invasiveness of the federal government, the impact that it has on our liberty. There's no instance where the government has more of an impact on someone's liberty than when it locks a person up in prison and keeps them there for years or even decades at a time. So the goal needs to be to impose a punishment that is just, that is consistent with the severity of the crime, that's sufficiently long so as to impose the punishment that's necessary, but we don't want it to be 1 day longer than that. Now, a lot of people in my party like to focus on the financial costs of lengthy incarceration. The financial costs are significant, to be sure. It costs about $30,000 a year to keep someone in federal prison. That is a lot of money. But in my mind, and I think the same way that Dick Durbin sees it and the way that most of our colleagues who have been part of this effort see it, the much bigger cost is not the financial one, it's the human cost. The fact that we're locking up a lot of people, a lot of husbands and fathers and nephews and uncles for years or decades at a time isn't right. So we've come up with a piece of legislation starting out with something called the Smarter Sentencing Act that brought about some gradual but necessary reforms to our criminal justice system, dealing primarily with nonviolent drug offenders. This ended up becoming part of a broader effort that we now call the Sentencing Reform and Corrections Act. That deals not only with minimum mandatory penalties, but also on the corrections end with getting people ready to be released from prison, allowing people to earn good time credit, basically, if they are low-risk offenders and if they take certain courses that will prepare them for civilian life outside of the prison. We find that we can reduce recidivism rates if we can get the people the right training and the right kind of counseling. I'm pleased to say that although this effort has been difficult, there's been no stage of it that has been anything other than sort of like pulling teeth from someone who's not sedated and has very sharp teeth. There's been no aspect of this that has been easy. But I'm pleased to report that last week, just this last Thursday, the Sentencing Reform and Corrections Act passed out of the Senate Judiciary Committee, on which I serve, by a vote of 15-5. And that's a pretty darn good vote. This was an overwhelmingly bipartisan vote. The Democratic Party is still stronger on this issue than my party is, but my people are coming along too. We hope and expect to get this to the Senate floor sometime in the next few months. I'm told that it's making progress in the House as well, but I look forward to the day when we can get that passed into law.
So I wonder if Steve Bright or Judge Kozinski wants to respond on this question of either mandatory minimums or general overcharging or prison transition back to society?
Well, you know, like Senator Lee, and perhaps like all of us, I'm shaped by experiences, and I had experience some years back, many years ago, of sending somebody to prison for 20 years on a mandatory minimum. And it was a tough case in many ways. It was a project, it was a case out of the projects in Los Angeles. And there were complaints by the citizens that they couldn't send the children to school without having somebody trying to sell them drugs. So quite properly, the law enforcement came in, and anyway, the defendant got arrested. And he wasn't a bad guy in many ways. He sold a small quantity. He had a family. He was living with his family. He had small children. Unfortunately, he had a couple of drug priors. I think they were possession priors. They were not sell priors. And the government chose to only present one of them to go easy on it. If they presented both of them, I would have had to face a 20-year, he would have gotten life. Having presented only one, which I couldn't but find that it was true, because it was true, I was forced to give him 20 years in prison, and I said much on the record that I thought this was an unduly harsh sentence that would destroy his family, and that nothing good will come of the fact that he was sent to prison. Now, I've been a judge long enough where I've actually been able to send people to prison for 20 years and seen them come out. And some years later, long after I'd sort of forgotten about the details of the case, it came back on my desk because he was out on supervised release, and he was involved in some violation. And he came with his lawyer, and he was a shadow of himself. He had been a fairly young, vigorous man. He was not a drug dealer. He was somebody who had many other, he was putting bread on the table in other ways, but he got sucked into drug dealing, doing a little bit of drug dealing on the side. His family did not know him and wouldn't know him. He didn't have a job. He didn't have friends. And he was just essentially a life wasted. These are terrible things we're doing to people, and I can't say how pleased I am that this is being taken seriously on a bipartisan basis. I think it is highly commendable, and I think you and your colleagues deserve our thanks.
Steve, do you want to weigh in on?
Well, I would just say, Senator, I commend what you're doing and what you and Senator Durbin are doing. This is long overdue. I know from representing people and so forth, this is ruining people and communities and families, and really something needs to be done. I know that what you have already in dealing with the federal system is a very heavy lift. But I just want to say one thing about the state systems, because that's where the huge number of people in prisons are, out of the state courts. And of course, many of them are serving mandatory minimums, life without parole. We just recently got a fellow out, it was 31 years for, a very small amount of cocaine. He had been sentenced to life without parole for that under recidivist statute. But 31 years, and even though he had life without parole, not a single disciplinary. Back to his family, restored to the community, but only because we took his case. But this is what's going on, I think, is the system is so out of balance, and largely because of federal grants. Billions and billions of dollars are going to law enforcement, to prosecution, and I'm not saying that shouldn't be done, but I'm saying that what's happened is this system is so out of balance that the poor person accused of crime, who's represented by a lawyer who may be carrying 500 cases, is not getting a fair shake in a lot of state systems in this country. And it's because there's such a tremendous amount of resources on the prosecution side, and a lot of people don't have lawyers at all on the defense side. And I think, we made a commitment. The Supreme Court decided Gideon versus Wainwright in 1963, and yet today it has still not been implemented in a number of states in this country. And I hope it is a federal right. It's a federal constitutional right under the Sixth Amendment. And I hope you will take a look at that as well.
Senator, do you want to respond?
Sure. I do agree that the system is out of whack, and Congress has perpetuated the imbalance there. I just had a flashback a moment ago. Remember, nearly 20 years ago when I was in law school, I went to a symposium put on by the Federalist Society, the National Students Symposium. Judge Kozinski was there on a panel, and I believe Nadine Strawson, then the president of the ACLU, was on the same panel. And
At Harvard, right?
this one was at Stanford,
Same place.
96, I think. Same place, yeah. This one was in your circuit, so. But I found myself agreeing with both of them. Now, Judge Kozinski is not often regarded as the identical twin of Nadine Strawson, and yet the members of this panel seem to agree that we had over-federalized criminal law. And this manifests itself in many ways. I spoke a few minutes ago about the fact that we have a lot of minimum mandatory penalties and we've occupied too much of the sphere. And this has a lot of a lot of side effects. One of them being that sometimes when you have state and federal law enforcement working side by side together on task forces or whatever, they'll sit down and they'll decide, okay, in which system will the would-be defendant get the most time in prison? And that's very often how it's decided. I mean, there's not much more to it than that. Okay, well, a lot of the time, the person will get a lot more time if he's prosecuted federally, so they prosecute him federally. And that messes up everything. It makes the whole system lopsided, and it doesn't work.
Right.
As far as Gideon v. Wainwright not being implemented properly, I'd love to know more about what you're talking about and what can be done on that from a federal level. Do you want to tell me what you're talking about there?
Well, I mean, we just in a lot of states lack structure. There's no structure. Anybody with a bar card and who can still breathe is appointed to represent people. I mean, we've had capital cases, 3 in Houston alone, where the lawyers slept while they were supposedly defending somebody in a death penalty case.
Yeah, that's usually not regarded as effective assistance of counsel.
You'd be amazed how much the courts agonized over that. I said, it doesn't say much about the right to counsel when we're agonizing over whether a lawyer sleeping during a death penalty trial violates the right to counsel. But the Fifth Circuit divided very bitterly on that question, finally holding that it did, but with a very bitter dissent along the way. But I say that's what it means to have the dream team in death penalty case in Houston. But in terms of knowledge of, the Supreme Court just reversed a case we were talking about earlier, just in March, where a fellow was convicted and the defense did not hire a competent expert to testify. When the case was sent back, actually there was no case there, and the fellow was released at 20 years. He had been in prison at that point. We're just seeing a lot of cases, and the other thing is just the case loads, that when you're representing 300 people, you don't even know who all your clients, you don't even know what their names are, let alone investigate their cases. I mean, I sit in courts where people are brought in, meet a lawyer, talk to them for 10 or 15 minutes, plead guilty and are sentenced, and then are taken back, and that is their entire time with the lawyer and time with the court. And it's called meet 'em and plead 'em. It happens all over this country. And it is a time when I think everybody in the system knows that it's a complete farce. I mean, there's no interview, there's no investigation, there's no looking at any of the legal issues in the case, there's no nothing. And yet we go through this pretense by going through the plea colloquy that somehow this person's satisfied with their lawyer. How would they know? I mean, I don't know. They just met this guy for 5 minutes. So how would they know whether to be satisfied or not? They don't know what a real lawyer does. But this is happening. And part of it is because the system is just crushed with the numbers. There are just so many people going through. And again, these tremendous prosecutorial resources. If there's a state federal drug task force, they're just out there arresting people right and left. There's nobody to defend them. And so all these people come into the system, and then you have a handful of public defenders who are trying to represent a very large number of people. One of our offices in Georgia, the public defenders are handling about 560 cases apiece. It just can't be done.
That is alarming. It is a huge problem. I come at this with something of a disadvantage in the sense that basically my entire career has involved practicing in the federal courts.
Right.
I've got very little experience in the state courts and no criminal experience in the state courts whatsoever. Right. My understanding is that there is a huge disparity within the state systems as far as the quality of representation you can get with court-appointed counsel, with indigent counsel. One thing that I am familiar with is the quality that we get within the federal system. That is, by the way, one of the things that I think we do right. One of the things that we do well within the federal system is the federal public defenders are really good. At least in my state, they were fantastic. I consistently found them to be as good as, and in many cases better than, any of the private non-indigent counsel that were available in our state. They were as good a lawyers as I've ever worked with. And so I think that kind of thing ought to be the gold standard.
I think that's the model. But unfortunately, in the state side, you know, there hasn't been the leadership to provide the funding. Now, some states do. Colorado, some other states have excellent public defender systems. I'm not saying it's universal, all 50 states, but there are a number of places where there's just not the resources, not the structure, not the independence that's needed so that people accused of crimes are actually properly defended. And that's why we have a lot. That's the first defense against innocent people going to prison, is to have a competent defense lawyer.
And I think what that takes is a commitment on the part of the government in question,
right.
the state, as we're talking about now, to put enough money into it. And the reason we have good federal public defenders in this country, pretty much nationwide as far as I'm aware, is that we put a lot of money into it. We pay them well. To get good lawyers, you're going to have to pay them well, and I think each state really needs to look at that. If they can't afford what they're doing, then they need to reevaluate what else they're spending money on. In other words, if they're putting more money into law enforcement than will allow them to adequately fund the provision of court-appointed counsel, I think they need to reconsider their priorities, because it is not it's not consistent with our understanding of due process, with our understanding of the right to counsel, to say that you've got a right to counsel regardless of whether you can afford one, but then not provide an attorney who is competent.
Can I exercise my moderator's privilege, because we're going to take questions in 1 second, but I want to ask the three of you just a journalist's question, and that is there a tipping point at which, I thought Cameron Todd Willingham was going to be the tipping point. You know, whoops, we killed a guy who was probably innocent, and you reference him, Judge Kozinski, in your article. DNA exonerations, you know, I thought the first 10, the first 20, 50, 100, that might be a tipping point. It seems, you know, arson scientists, they apparently make things up a lot. The odonture guys who, you know, use tooth molds, and we seem to get stories week after week after week of just profound failures in the system. And yet I think every one of you has said in a different way, there's not a tremendous amount of public will to effectuate the changes we're talking about. It's a heavy lift to really modulate and moderate our, you know, the way we over-criminalize and the way we have over-incarcerated. And so I guess the question is, how does this change? How is this going to change if we're either unshockable in this country and the execution of innocent men doesn't affront us, or just simply because there's no constituency for being softer on crime? How is this going to change? Where is the tipping point going to come? It seems to me it's going to come in bipartisan action and not public will. But I just wonder if any of you have thoughts about how this changes.
Well, it's called leadership, and you know, the public is led to certain beliefs, and I think what we see here and what Senator Lee and his colleague are doing is showing leadership. It won't change, and hopefully this passes. It won't change what happens in the state systems, but it's an act of leadership. I think the fact that more judges are doing what Judge Gertner is doing, which is looking closely at forensic evidence, what Judge Gertner did when she was a judge, looking closely and second-guessing experts in criminal cases, that's an act of leadership. It not only sets a precedent, but it also causes other people like me, who, you know, I'm not a trial judge, so I don't do this stuff, so but I read about it, and that changes my mind, and hopefully this changes the public's view. I think the reason we have not had more concern before is nobody has rung the bell to say we are having a problem. And I think what we're all doing here, and I think this is a good thing, is to ring the bell and said we are having a problem.
Well, I agree with the part about leadership, and I just point out that one of the reasons the federal public defender system is what it is when Gideon was decided, the Attorney General of the United States, Robert Kennedy at the time, went before Congress and asked for passage of the Criminal Justice Act to establish the federal public defenders and the Criminal Justice Act provisions for private lawyers being compensated. Interesting thing, Gideon came out of Florida. When the decision came down, Ferris Bryan, the governor of Florida, called for the legislature to create a public defender system in Florida, and within 3 months of the decision, Florida had a public defender in every judicial circuit in the state, parallel to the prosecutor's office. Unfortunately, in so many other states, nothing happened at all. I mean, it was left to conscription or just, you know, just appoint whatever lawyers sitting around the courtroom. But I think on this question about there's no constituency for being soft on crime, I think what you offer so much, and your colleagues on your side of the aisle, Senator Lee, is to say this is about being fair on crime, that we do not serve the public well when we put away innocent people and the perpetrators are left out there to create more crimes. I mean, Michael Morton's case is a good example where the person went on to commit another crime where if it had been properly dealt with to begin with, that would not have happened. But that this system has to be fair. And that's not being soft necessarily. That's just making sure that we are arresting the right people, convicting the right people, and that we're sentencing them to sentences that are appropriate, appropriate for what they did. Like you said, what they should get and not a day over that. And treating them in a way that's individual. If they've got drug problems and they can be dealt with their addiction, deal with them one way. If they're a mass murderer, then they're going to obviously have to be dealt with by being sent to prison or whatever. But unfortunately, we're just treating this as a faceless mass going through the systems.
I think you're right. I agree with all the points that both of you have made. I would add to that. I've had a lot of trial and error in this process in figuring out what works and what doesn't work. I've had a lot of conversations with fellow senators, particularly fellow Republicans, that have not been successful, and then I've had others that have been. And so I've learned a little bit what works, and at least when dealing with Republicans, what I've found works best is when I approach it from the standpoint of telling stories. I tell stories about Mr. Angelos, or I tell stories about a gentleman who was prosecuted in the Sixth Circuit, who ended up receiving a 15-year minimum mandatory sentence. He was a convicted felon and was therefore not allowed to possess firearms or ammunition. He was laying carpet in the hallway of the building where he was renting a room. He was trying to earn an additional month's rent. And as he was laying carpet, he discovered a single round of ammunition. It was a .22 caliber bullet. It had to be moved like any other item, whether it was a Matchbox car or a popsicle stick or something else. He had to remove it. So he picked it up, he put it in a box, and he forgot about it. He was later prosecuted for possessing that one round of ammunition, that one .22 caliber bullet. He received a 15-year minimum mandatory sentence. When I tell that story, or when I tell the story about Weldon Angelos, and I connect it with the name of an individual person, a real person, I tell them a little bit of background about the person's life, about the fact that Mr. Angelos had 2 children, about the fact that he won't see them until he's 80 if he serves his whole sentence, then people start to listen. Otherwise, especially with Republicans, immediately when you start talking about adjusting minimum mandatory sentences, they get all antsy and they start saying things like, I don't want to be soft on crime, I want to be tough on crime, and we shouldn't be coddling people. But if you can tell the human side to it, people listen. I do want to say also, I agree with what Judge Kozinski said about the fact that it does takes leadership, takes people willing to step out of their comfort zone and willing to talk about it. And I want to commend President Obama on this. He has done a lot of good in this area as far as making people aware of it and bringing people together on this issue. And his efforts have been very helpful.
So we are at the portion of the show where we are going to take questions, but I want to be mindful of your time, Senator. Do you have 15 minutes to take questions, or do we release you?
My scheduler told me I have to leave by 6:45, but she can't yell at me too much if I wait 5 more minutes.
Okay, I will yell back. So let's take a few questions, and maybe if you have a question for Senator Lee, you can go first because he's only got a few minutes. So yeah, right here.
I don't know. I've reviewed it resulted in an appeal, and I'm getting my facts from what I was able to glean from the F3rd, from the Sixth Circuit's decision in that case. I don't know what the prosecutor was thinking. Perhaps they thought that he was just a bad guy generally and they had to go after him. I don't know, but in any universe, I think that is wrong. Even if they had thought he was a bad guy, that they thought he did something else wrong and they were going to get him on this, it's just crazy to send him away for 15 years for possessing a single bullet.
Well, I had the same question on the first case you described, the Angelo case. What was the backstory there? I mean, why wasn't some prosecutorial discretion exercised in the charging there?
They were trying to get him to plead, and I think in the process of trying to get him to plead, they played these cards, and he didn't plead, and then they went through with it, and yeah.
Okay, yeah, question back here. Loud as you can.
Okay, so you're saying this resource center was federally funded? Was it federally funded for the purpose of assisting lawyers practicing in state courts?
Yes, what it was, Senator, was there was a real problem with capital cases where there were no lawyers for people. And it was a joint, the idea was the states would put in money for the representation in state courts and the feds would put in money for the representation in federal court, but there would be continuity of counsel and the people would be specialized in habeas corpus cases and capital cases. And those existed for some period of time until the Gingrich revolution, I guess you would say, and then they were defunded completely. But they were in virtually all of the major death penalty states.
Okay, and the funding was part federal, part for the specific reason that some of these were going to be in federal.
Well, all these cases were going to go into federal habeas, right? So they were first in the state post-conviction process and then in the federal post-conviction process. And so there was quite a bit of I think 18 million, I think, was about how much was coming in from the feds on that, the federal government. And that was just zeroed out.
Interesting. I was not aware of that. I'm happy to look into it. It's an interesting thought, because you're right. I mean, there is given that all of them are going to go through the federal habeas system, I can see a federal nexus there. I'm happy to look into it.
And I might say one reason really it needs to be looked into is, you know, there are 80 people who've missed the statute of limitations in death penalty cases for filing their federal habeas corpus. So those people are going to be executed without life tenure federal judges ever reviewing their case.
Without any 2255 ever being reviewed?
Right.
Wow.
Because there's a one-year statute of limitations. In fact, talking about Texas lawyers, there's one lawyer who's missed the statute of limitations 3 times. Now, I don't know why he hadn't been disbarred, but he's still being appointed to represent people in capital cases in Houston, Texas, as we speak.
Yeah.
One more question?
One of the next projects that I have, one of the next areas where I think we need some real reform, just relates to the number of criminal offenses that we have on the books at all. Now, remember, the majority of the people in prison right now in America are in prison within a state system. And I'm not a state legislator. I don't have any jurisdiction there. And so my focus is necessarily on the federal system. But in my part of it, my focus is going to be on the number of crimes that we have out there. And in particular, the number of crimes that we have out there without a mens rea requirement. where you've got a criminal statute that doesn't have a mens rea element. This is insane. One of the reasons why this is so difficult and so important is that up until this very moment, we don't know how many federal crimes there are. We've asked the Congressional Research Service to do a report on this, and they came back to us saying, we don't know. This is unknown, and it's unknowable. We cannot figure it out. And so part of this, this legislation that passed through our committee last week, the Sentencing Reform and Corrections Act, requires a comprehensive study to be done where we actually know that number. Once we have that number and we can catalog those, then we're going to start identifying the number of crimes out there that in one way or another are going to result in prison time for basically malum prohibitum offenses, or in many cases for offenses that have no mens rea requirement attached to them. And I think that's a place to start. The good news also is that I mentioned that most of these prisoners are in state prison systems. There are corresponding efforts going on around the country. In my home state of Utah, we've got a criminal justice reform effort underway right now that's seeking to reform our sentencing laws because we're recognizing what we're recognizing here. So anyway, there's hope on the horizon. I don't know of a good place to start. I just pick some of the areas that where I think there is the most blatant overreach currently, and that's where I'm starting.
I want to ask you to join me in thanking Senator Lee for his leadership on this issue, and also for co-sponsoring this event. And we've got 7 minutes for the other panelists to answer the question of how we get from 25% to 2% incarceration rates in this country. We're exchanging business cards.
Sorry, that's okay. Oh, thank you.
Senator, thank you so much. Does anyone else want to take a crack at the question that was just asked of Senator Lee in terms of these first-time drug offenses are a drop in the bucket? Is there something else?
If Steve has something to say on that, why don't you go first? I was going to actually go a little bit sideways on that issue. And the people in prison are a big problem, but we have another problem in this country, and that is that it has become very difficult to shake your past. The idea that you commit a crime and then you've paid your debt to society and then you take your place in society more or less unscathed, or you've paid, you're now even, is just gone. I mean, don't even go to talking about anything that might be a sex offense. I mean, a 17-year-old boy that sleeps with his 13-year-old girlfriend gets convicted. That's a sex crime. He has to register for the rest of his life in most states. They put it on the internet. Just go, I mean, it's chilling. Just go put in your address in one of those maps and see how many sex offenders live within easy walk distance of your house. And then when you drill down and see what they have actually committed, but other kinds of crimes, it's very hard to get unconditional pardons, expungements, all the things that really give one a chance when you come out to have a crack at a real life. And of course, if you don't give people a chance to pick up their life and have a normal life and have normal opportunities, then the chance of recidivism is vastly increased. I had a case that's pending. I probably can't say very much about it, although the hearings have been public. But this is somebody who's a supervised release, and he's come out. I sentenced him. He came out. And he actually has a job, and he actually joined a union or a trade union, and he's making progress towards getting his certificate. And it's been a struggle, but with the understanding of the U.S. Attorney's Office, who have been very good about this, and the probation office in Los Angeles, we have managed to, despite some mishaps, we have managed to keep him working and learning and getting to a certificate, because that's the only chance he will have not to wind up back in prison, back offending, back expense to us. I'm sort of cheap that way. I'd like to turn some of these people who are coming out into productive members of society. And that's a huge problem, I think.
I couldn't agree more.
And I don't think enough attention has been paid to that.
It's a very good insight. Yep, right here. Loud, loud.
Absolute prosecutorial immunity.
You're saying, Alex, you're saying qualified immunity, right?
I think prosecutors get absolute immunity.
Well, they do, but your proposal.
I'm saying do away with absolute immunity. I think you would have to maintain qualified immunity. I think you would have to. But absolute immunity, the Supreme Court adopted it 20 years ago or 25 years ago, and the idea was that, in a Supreme Court opinion, and they said there are all these other ways in which prosecutors can have direct consequences. Like they could get prosecuted themselves, and if they do something truly wrong. Well, you can count on the fingers of one hand of the number of prosecutors who have actually been prosecuted for things they've done wrong as prosecutors. And we've now had a lot of experience with it. We know that once in a while, just like every other job, there are airline pilots who go bad, there are police who go bad, there are judges who go bad, and there's no reason to think prosecutors don't either. They have a tremendous amount of power, and power tends to be the kind of thing that leads to abuse. And most people who go to be prosecutors do a terrific job and are competent and honest and scrupulous and resist the temptation, but you would know that some will not. That's just human nature. And the Supreme Court had this idea that, well, there are these other remedies. Well, there aren't. So I suggested that there's a time to go back and reconsider absolute prosecutorial immunity. We could have a conversation about whether it should be, whether you should have qualified immunity, but I think it's certainly if police have qualified immunity, other state officials, I don't see why prosecutors should be any different.
I think these immunity doctrines, just tremendous injustices result from them, and I think one of the reasons that many prosecutors are so arrogant and feel like they're just above the law is because of that. No matter how terrible the activity is, no matter how malicious the prosecution, and sometimes these prosecutions are for political reasons or to pay somebody back for this, I mean, have nothing to do with law enforcement or whatever, and there's absolute prosecutorial immunity, so nothing happens as a result of it. And this John Thompson case where the fellow was almost killed, New Orleans got a jury verdict of $15 million, and then the Supreme Court took it away from him. It just really, there's no accountability. Harry Connick's office in New Orleans, I mean, there's so many instances of prosecutorial misconduct in that office of hiding Brady material and all that, and it's only the tip of the iceberg. It's just a totally corrupt office. They should have been prosecuted and put in jail probably. But, you know, Connick retired and nothing ever happened to anybody. For all the misconduct that happened not only to Thompson but to Curtis Lee Kiles and a whole group of other people who were prosecuted by that office.
We're going to take one more quick question. I know folks have questions. I'm sorry.
I have a question about juries and death penalty. Why are people allowed to strike people who do not agree with the death penalty, but not allowed to strike people who do agree with the death penalty? I mean, that we had no one possibly, but shouldn't that issue not be asked, and the issue of the death penalty be allowed to be discussed in the jury, which is supposed to be our peers?
Well, I think that's a good point. I think the answer to the question is because the Supreme Court says that. The Supreme Court has said, you know, if a person is so conscientiously opposed to the death penalty that they can't consider both punishments, then they can't sit on. So you have a jury. This Boston Marathon case is a good example where you have a large part of the population opposed to the death penalty, so they're all excluded from participation in the jury. So you got South Boston and rural Massachusetts on the jury, and you've got a jury that's very inclined to give the death penalty, when actually if you had a jury that represented the community, they wouldn't have it. That's the best example I can give you. I would say this, the law is that if you have a person who feels so strongly in favor of the death penalty that they can't consider a life sentence or a life imprisonment without parole sentence, that person might be excluded. But it's a very different question, because what the judge will always do is say, Mr. Jury, you have to consider both punishments. Now, of course, for the person who's opposed to the death penalty, they can't consider the death penalty because they're conscientiously opposed to it. They're morally opposed to it. But for the person who's adamantly in favor of the death penalty and thinks anybody who commits a certain crime ought to get the death penalty, once they're educated a little bit by the judge, of course they can consider life imprisonment. It may be a very fleeting consideration, but they can consider it. So it's a totally out of balance. Well, and the jury is supposed to be the conscience of the community, but it very often is not representative of the community at all because of that. And also, it's a big factor with race, because a lot of African Americans in the South are going to be excluded because they're opposed to the death penalty because of the historic discrimination in the use of the death penalty. That'll get the numbers down to a small enough number, they're already a minority, and then the prosecutor will strike the rest. So you have all white juries trying black men in death penalty cases all across the country.